Now we'll transition into kind of some kind of the intricacies of some buzzwords and a really Herculean effort that was taken on in a very short time frame in the interim of the legislative session. I think y'all should be able to basically pick a chair and a mic so that y'all don't necessarily have to come back and forth if you don't want to. As long as you can actually still see that screen, which Shauna may not have a problem, but I know Russ has his glasses. So, but certainly not going to, kind of step on the toes. Let them lay out the process that they went through in starting this discussion on the application of the oil and gas principles to groundwater. Again, please welcome Shauna Fitzsimmons and Russ Johnson.
Okay, so when Shauna and I speak, there's always a debate about who gets to go first and who gets rebuttal. And she won again. She gets rebuttal.
Really nice.
Yeah, that's what she said, but just wait. So we've been given the topic of great discussion and debate, which is how much of the jurisprudence of oil and gas is going to be or is applicable to management of groundwater by groundwater conservation districts in light of the history. And just to kind of put it in perspective, and where do you know how to operate this thing?
Probably that arrow.
This arrow?
Yes. Maybe, yeah.
So it's true, I can't see that. Oh. So, the title is The Application of Oil and Gas Law to Groundwater. And really, this was the reason I think you're looking at the two of us, was that we were given the unfortunate task of co-chairing the Texas Water Conservation Association's stakeholder effort to provide information to the legislature on this question, since there was a lot of suggestion that Chapter 36 needed to be amended to address the implications of the application of oil and gas law to groundwater. And there was, of course, lots of concern that literal application would be difficult. At best, probably inappropriate, but don't quote me on that. Texas Water Conservation Association appointed a subcommittee to basically outline the issue for the legislature, and we went to work with stakeholders on both sides, if you will, in analyzing the pros and cons, if you will, of the application of oil and gas law to groundwater. And, just to give you the brief summary, if that's possible. Oh, look at this. What's this, Shauna? What have I done
You've
now?
gone too far.
I've gone.
Back arrow.
Back arrow.
There you go.
Okay, so, just to kind of put it in perspective, and I think this is important. Obviously, the Supreme Court adopted the absolute ownership rule in 1904, and then, in essence, the Texas courts went to sleep for about 50 years until the drought of the 50s in dealing with what that meant in the context of groundwater. But we had, and of course, the conservation amendment was passed, et cetera. But really, until the drought of the 50s, starting in the 40s, there was no groundwater regulation in Texas, and therefore this question of the evolution of groundwater law existed in the limited context of waste and the rule of capture, and we all know the cases. But all that changed, and all that changed really, I think, with two things. First, the Harris-Galveston situation with subsidence, but more acutely with the conflict in the Edwards Aquifer region generated by the connection of the groundwater source to springs that were home to endangered species, and the creation of the Edwards Aquifer Authority Act. And then, of course, Senate Bill 1, which, using what I call the video game analogy, powered up groundwater conservation districts to give them real regulatory power over managing groundwater use. So those are kind of the combinations of things that, you know, kind of led to this, I guess, this question of what's the framework within which this regulation must occur? And to what extent does oil and gas law inform that discussion? So I guess that means we go to the next slide, which, you know, we put this in here because it was the first instance where the courts really addressed this question of the nature of the ownership right in groundwater, specifically in this case in the context of a sale of the surface by a landowner to the city of Del Rio. But in the deed, the landowner reserved the groundwater rights associated with the tract that had been conveyed to the city. And then you got to love it, the city drilled a well on that 10-acre tract and was producing water for their municipal system. And the landowner who had sold that tract and reserved the groundwater rights said, wait a minute, you're producing my groundwater. And the city defended basically by saying, oh, well, wait a minute, this right that you tried to reserve is an, you know, inchoate, usufructuary right. It is not a vested right, and therefore couldn't be severed. And particularly since you didn't reserve any of the groundwater access, surface access necessary. The Fourth Court of Appeals basically rejected that argument, found that it was a property right like any of the other property rights associated with fee ownership, and that like those other rights, it could be severed from the surface estate. And in that case said just because there was no reservation of surface rights, the landowner owned the adjoining tract and therefore could access the groundwater that he had reserved. So the next real, you know, kind of evolution or step arose in the context of the implementation of the Edwards Aquifer Authority legislation and the obvious implications of that legislation, which attempted to cap the total amount of production from the Edwards Aquifer and allocate that available water supply first and preferentially to historic users. And to make the very long story of the Day case short, Day was denied a permit, felt that he was entitled to a permit, and sued, claiming that he should have gotten a permit, but oh, by the way, if I didn't get a permit, you have taken my groundwater right, and that's prohibited by the Constitution. And the Edwards Aquifer Authority and Greg Ellis, and I know he's out there somewhere, basically defended that claim, saying this is not a vested right. You can't quantify it. It doesn't have the indicia of ownership that all other vested rights have, which is the ability to exclude others from using it. So therefore, it's not a vested right. To make the very long story short, Supreme Court resolved that question by finding that it was, like the oil and gas right, a vested right protected by the Constitution. And, you know, as I like to say, the Day case, in a strange sort of way, is kind of like the Bible. You can find any interpretation that you want in the language of Day. There's plenty of support for almost any position that you take with regard to this ownership right and what the nature of that vested right means. But it's clear, is clear, that the principle that had been applied to oil and gas, and that is that it is a vested right, owned in place, and that the landowner is entitled to their fair share of that owned resource, was affirmed. You know, Drew will likely say that it was first recognized in Day, but I think it was an acknowledgement that that's what it had meant all along. And then finally, before we get into the real detailed discussion, and Shauna explains what the problems are with just the literal application of oil and gas law to groundwater, we have the Coyote Lake Ranch case, which does two really important things. First, it incorporates into groundwater law the concept from oil and gas that when you have a severance of the two estates, the surface and the groundwater, that like in oil and gas, the groundwater severed estate is the dominant estate, and the surface estate is the servient estate. What that means in the oil and gas context has always been that if you own the minerals, you have the right to use the surface to extract those minerals, even if the deed doesn't say so. So you have all the rights to the surface you need to get your minerals. Well, the Supreme Court in Coyote Ranch said that same principle applies to a severed groundwater right. So if you're a purchaser of land and the seller just simply reserves in the deed the groundwater right, that is inherently reserving the surface rights necessary to obtain that groundwater on that piece of property. But secondly, it applied the Supreme Court doctrine established over half a decade ago that the mineral owner had to exercise that right, respectful, if you will, of the surface use, and had to, in essence, address damage to that surface use if their oil and gas operations interfered with or diminished the value of that surface. And I won't go into the elaborate details of the accommodation doctrine. There are whole, CLE presentations on it. But the bottom line is that's a principle of oil and gas law that was directly applied to groundwater. So that leads to this question of how much more of groundwater law, specifically the concept of correlative ownership of the resource, applies to management by groundwater conservation districts. And I'm just going to introduce what Shauna is going to say from my perspective by saying, Supreme Court's made it abundantly clear, I think, and Justice Heck wouldn't confess it this morning, but I think he implied it, and that is that they're going to look to the oil and gas law for guidance on how to apply these ownership principles to the regulatory conflicts and disputes among landowners in the future. And in the context of groundwater management, to the extent your groundwater management departs substantially from this recognition of an ownership interest vested in the landowner, that is a potential challenge to that form of regulation, since it could be argued that it fails to recognize the shared ownership and allow for the reasonable opportunity to recover your fair share. So with that, here's the real wisdom. Shauna will explain how we tried to parse that in this presentation to the legislature.
Thanks, Russ. Good afternoon. So yeah, I think what Russ has covered so far is basically what oil and gas law has, oh God. Is that gone? Sarah?
And I didn't touch it.
I think I did. Okay, scary. So Russ talked about, which is really important, especially for board members in the room that may not be really aware of what's going on in terms of oil and gas law being applied to groundwater law. Russ did a good job of covering exactly what has unquestionably been applied from oil and gas law to groundwater. And that is generally in the context of ownership and relationships between severed estates. However, as Justice Heck touched on this morning, which I just want to point out that I really am geeking out over seeing him today. I feel like I've just seen Brad Pitt or something. I've spent 10 years of my life dedicated to studying oil and gas and groundwater, and I felt like I couldn't even be in the same room as him. It was so weird. So it was awesome to have him here today and talking about that. He kind of touched on the fact that while they have turned to oil and gas legal principles to resolve issues in groundwater, there are inherent differences in the resources. So some of those differences in the resources are listed here. There's differences in the nature of the resource, and what I mean by that, or what we meant by that in the white paper specifically, and it goes, I'm just going to kind of highlight these issues which are in the white paper, and you can access it on the TWCA website to get more information. But the differences in the nature of the resource, you got to look at the fact that, you know, if you don't have groundwater under a surface estate and there's no available other resource for water in the area, that could potentially impact the value of the surface estate. So stuff like that. Looking at the different functions of groundwater versus oil and gas. In oil and gas, you don't necessarily have any value in leaving the resource in the ground. It's focused on maximum recovery. Whereas in groundwater, there is value in making sure that that groundwater stays there because you have issues like recharge, sustainability, that you don't have in oil and gas. You have issues like subsidence and spring flows and base flows. Keeping that groundwater in place under the ground is important, specifically in certain parts of the state. So that's kind of how the two resources are different. There are also different goals in regulating the production of the resource that we've talked about extensively. In oil and gas, the primary goal is for maximum recovery, and at the same time ensuring that landowners are fairly compensated for the recovery of those minerals based on their fair share. In groundwater, it's different. Your primary goal is long-term availability of a water resource that also protects private property rights, but balances conservation and the development of the resource using the best available science. You know, we have stuff like DFCs. That's not something you're needing to consider, obviously, in oil and gas. Differences in how the resources are regulated. Obviously, oil and gas, you have the Railroad Commission. In groundwater, we have 100 or so groundwater conservation districts that just have partial jurisdiction over the resources and have to work together in managing and preserving and conserving those resources. So now that we know where the court has applied oil and gas law, which is primarily ownership, thinking about how the court may look to oil and gas law when they start looking at groundwater districts, managing and regulation of the resource. And this has kind of been a really hot topic in terms of legal disputes we're seeing at the GCD level, as well as discussions that are occurring at the Capitol. And it's exactly what prompted this paper, specifically correlative rights and the whether it's considered legal or within groundwater district's authority to adopt so-called user-based rules. So we kind of have seen these two camps. You know, are you pro-correlative rights or are you pro-user-based rules? Where in the long run, and we'll get to this at the end, I think the message we need to take away from this meeting today is those two camps are not mutually exclusive. So what we came to find out at the beginning of this fun project of white paper, we all sat around in a room and went around and asked, what do you think the term correlative rights means? And I think if I asked everyone in this room, everyone would have a different answer. It was extremely eye-opening and very interesting to see how people viewed this term and what it meant. What we are using that term in many cases, or what I have heard people use this term correlative rights to mean, and I'm guilty of it as well, is a shorthand term when we talk about groundwater regulation that is based exclusively or primarily on surface acreage ownership. So a regulatory system that allocates groundwater in the sense that if you have, you get X acre feet per acre you own, and that's it. And that's how the MAG's distributed. And so at the end of the day, when we really took a hard look at correlative rights and its applicability in groundwater, A, that's not what the court said in Day, nor has the court ever said that in any other case. And B, that is not what oil and gas is doing, and that is not how oil and gas law recognizes correlative rights. So this is the fun blurb that has triggered all of this discussion on correlative rights and groundwater. The court made this statement in the Day case, talking about correlative rights and groundwater, in oil and gas. And the court said correlative rights between the various landowners over a common reservoir of oil and gas can be recognized through state regulation of oil and gas production that affords each landowner the opportunity to produce his fair share of the recoverable oil and gas beneath his property or his land. Similarly, one purpose of groundwater regulation is to afford landowners their fair share of the groundwater beneath their property. So that's what all this commotion is all about, this one reference to correlative rights and its applicability to groundwater in the Day decision. But what does that mean moving forward and applying correlative rights in reality in groundwater? Well, as Justice Heck said this morning, correlative rights are a creature of regulation. So even though you are recognizing that there is concurrent ownership in a common resource that is only realized and recognized through regulation by whether it's the Railroad Commission or by local groundwater conservation districts. The court went on to talk about factors that groundwater districts may consider in recognizing correlative rights other than surface acreage ownership. Now, backing up a little bit, if you look at oil and gas, if this is what we're talking about oil and gas law application to groundwater, how does Railroad Commission regulate in a way that affords landowners their fair share or opportunity to produce their fair share? Well, they do it a couple ways. They have well spacing regulations, which space new wells from existing wells, minimum spacing requirements, very similar to what groundwater districts are doing. They also impose well density requirements, and that is more applicable to existing wells. Once you have a well in the ground, you assign a number of acres to that well, which allows for the most efficient drainage of that formation. And so again, that speaks to the fact that in oil and gas, your goal is to drain every single drop of that reservoir. That's not necessarily our goal in groundwater. There are also production allowables in oil and gas. However, we haven't had a production allowable that's been met in the last 50 years. So they're set so high that you could never achieve them. So in oil and gas, you're seeing you're limiting people's ability to produce unlimited amount under the rule of capture. You're limiting their ability to produce, and you're recognizing correlative rights, meaning concurrent ownership of a common reservoir, through primarily well spacing and well density requirements. That is not allocating based on surface acreage ownership like we're talking about with groundwater. So in groundwater, what can we do? The question is, what can we do and what factors can we consider in developing a regulatory system that recognizes concurrent ownership? And the court gave us a list of things to consider. Landowners' investment-backed expectations. That's exactly what the court talked extensively about in the Days case, and then we saw again in the Bragg case. Does a landowner that you're regulating or cutting back or limiting their production have an investment in the ability to produce that groundwater? Whether it's infrastructure, whether it's a farm, or before that groundwater district came in and regulated, did they have expectations that they were going to be able to produce X amount of groundwater? That speaks highly towards the recognition of historic and existing use, which is something you see in groundwater, but you do not see in oil and gas law. So most districts are kind of doing something like that, which is a grandfathering in process. So that's kind of what we refer to as user-based rules. You're giving certain users X amount of groundwater based on their historic and existing use and their investment-backed expectations. That is not tied necessarily to their surface acreage ownership. Historic use, another thing to consider, but as Justice Heck said, it's not the only thing to consider. Future needs, including relative importance of various uses. Justice Heck talked about that as well today. Agricultural use is not it's important, but it's not necessarily more important than commercial or, domestic use. Concerns unrelated to use, environmental impacts and subsidence, and this really speaks to the local nature of groundwater and the need for local regulation because, as we discussed earlier today and heard a lot of speakers talk about, in one part of the state, up in the Ogallala, they're not dealing with the same issues as Barton Springs Groundwater Conservation District is dealing with the Barton Springs and that sort of thing. So they have different permitting schemes in place. Like, for instance, Barton Springs Conservation District, what they do is they do more site-specific well testing type stuff. Looking at, okay, if you produce X amount, if we see impact to the spring, we're gonna have to cut you back, versus just guaranteeing you an amount of groundwater based on your acreage. So as I mentioned earlier today, I think what the hope of this paper is, and hopefully one person at the Capitol reads it before next session. I really appreciate Shannon Houston in the audience as my little white paper cheerleader. What we ultimately need to realize is that this concept of correlative rights and user-based rules are not mutually exclusive concepts. You can have a regulatory system that recognizes correlative rights that is not based solely on acreage ownership. You can consider other factors like the court listed in the Day case. And this is just a one sentence from the white paper that I think sums it up really well. It took about 3 days to get all parties to agree on that, every single word in that sentence, and a lot of fighting, kind of, back and forth, I should say, negotiating, but we got there, and I think it does a good job at summing it up. So that's it, and available for questions.
Yeah, and the only thing I'd add to that, just briefly, is that the court has clearly kind of outlined its view that the jurisprudence of groundwater is going to follow oil and gas, but I think Shauna makes the correct observation that they also recognize that the same principles don't apply. So I think the biggest is that this is regulation over existing use. So you have a historic backdrop to regulation that you don't really have in the oil and gas regulatory arena. And that is a huge impediment to a strict correlative rights kind of approach to ownership. But I would add this. To the extent the regulatory program departs from a recognition of the shared ownership of the resource based on acreage, there needs to be substantial reason for that departure to withstand, I think, what could be a claim that the landowner has been deprived of their fair share. So, and what was really surprising was how much we agreed with one another when it was all said and done.
Have any questions? Because that was, of course, just about as clear as mud as law can be, right? One question that I did want both of y'all to kind of lay out a little bit more and go into a little bit of detail, since we've got a little bit extra time, is the process, kind of again, this subcommittee process, the input that y'all had, and kind of the timeline that, again, if I remember right, the original plan was for this paper to be like 3 or 4 pages, 5 at absolute max, and kind of what it ultimately turned into through your survey process as well.
Right, so when we started this committee, it was appointed after the TWCA Groundwater Committee received a letter from Senator Perry's office with specific questions about correlative rights and user-based rules. We put together once we got our subcommittee group together dedicated to writing a draft of this paper to bring before the whole Groundwater Committee, we developed a survey just to kind of get a feel for where everyone was on a lot of these issues. And that was the most insightful thing I've probably ever done, to just see how people felt and what they believed the law was on these issues. So what we ended up having to do was kind of take a step back and start by saying, well, what law already applies to groundwater? What do we already know? And then building from that, versus just jumping straight into correlative rights and user-based rules and the legality of them and their applicability in groundwater management regulation. Well, where have the courts already said oil and gas law applies, and where have they said it does not? Or where are the similarities and where are the differences? So that was why it ended up being, I think it's probably 13 pages, and that includes a 2-page executive summary.
Yeah, and I'd just add, there are a couple of things that I think are going to have to be addressed by the courts ultimately, and the first is, to what extent can new users be restricted to protect that historic use in the context of a commonly owed resource? We haven't really talked about that this afternoon, but that's frankly, one of those wide open questions that a landowner who has, a huge amount of land but has never exercised their groundwater right and lives in a district that the district has determined has met its sustainable yield, however you want to call it, and substantially restricts new users to protect the existing users that are using the resource. I think you would agree that in the oil and gas context, that would be absurd to say, the only people that can produce oil and gas are those that have invested in a well. But on the other hand, as Shauna correctly pointed out, the Supreme Court says one of the big factors is investment-backed expectations. And certainly no one has better investment-backed expectations than the historic user. So there's that, plus this question of can you allocate the resource, manage the resource based upon need or use as opposed to land ownership.
Yeah, and the paper, for folks that are in the midst of trying to figure out a effective and defendable regulatory system, the white paper does a good job of, it sets the stage as what is the law, what are you required to do, but then it looks at what we call acreage-based regulations, or what we don't want to call that correlative rights anymore. But we just want to we call it acreage-based. So you're basically allocating groundwater based exclusively on how much acreage somebody owns. We have the pros and cons in the paper on those kind of regulations. And then the pros and cons on different types of so-called user-based regulations. So those would be helpful to look at. Most districts do a hybrid, kind of somewhere in the middle, and take from either side of those categories to develop something that works for everybody, and that's based on local conditions. So you can kind of pick and choose what works for your district while also staying within your legal requirements.
I know you can have another shot, so go ahead.
No, that was outstanding.
Are there any other questions? All right, please join me in appreciating their time and efforts on this study.